Good morning, everybody, and welcome to Wednesday morning's online seminar. Today, we are lucky enough to be joined by Brandon Silver, solicitor at Fletcher Day, who's going to be looking at construction essentials termination. Brandon will be talking us through as always, and if you have questions for him, these can be entered on the Q&A or chat facility in the bottom toolbar of your screen, and then Brandon will attempt to answer as many of those as we have time for at the end of the session. So I also should add apologies that if you have anything that you don't wish to raise in an open forum, you will see Brandon's email on the screen shortly. That's brandon.silver@fletcherday.com. He will always be happy to take any direct queries for you. Okay, Brandon, without any further ado, I will hand over to you.
Thank you, Julie. So by way of background, I'm a construction solicitor at Fletcher Day, and I deal with both transactional and contentious construction matters. So I will assist in drafting construction contracts and also dealing with any disputes between the parties. I act as a party representative for clients, and that is in a number of forums: adjudication, litigation, and arbitration. And what I would say is a common theme running now is that the disputes that we are dealing with are commonly to do with termination. That I would say is the hottest topic right now that we are dealing with. The reason I would say, and I'm sure you're not surprised, is that given the current climate, especially given COVID and the impact that this has caused in the construction industry, termination of contracts is all too often now. Parties do not want to complete the contract, whether for financial issues or any other reason, and therefore are trying to get out of the contract. So I thought it'd be prudent today to talk about this topic. Now, the first thing I must say, and this is the starting point, is that you cannot terminate the contract whenever you would like, unless you have a provision in the contract which says that you can terminate at will. This would be a provision in the contract which says that at any time you can terminate the contract. If there is no such provision, then you can only terminate the contract at certain times. And that's what I'm going to start off by talking about. If you do not have such a right to terminate, but you do elect to terminate the contract, then this will be a wrongful termination of the contract. And the other party can actually state that your attempt to terminate the contract is actually a repudiatory breach itself, and therefore they can terminate the contract and are entitled to damages. So the first example, as you will see on the slide, is that you have a right to terminate the contract when there is a breach of a term of the contract, which is so serious in itself that it'd be unreasonable to expect the other party to continue with the contract. So there's a few things I want to talk about here. The first thing is, well, what is a breach of a term of the contract? A breach of a term of the contract is where you do something that you're not entitled to do, or alternatively, you don't do something that you have to do. Now, as you can see, you can only terminate the contract under this situation where there is a breach that is so serious. The breach is a one-off breach that is so serious. And as you can see, it has to be a breach of a fundamental term or a condition. If it's a breach of a warranty, then you're not entitled to terminate the contract. So the question is, what is a fundamental term or condition, and what is a warranty? A fundamental term is a term that goes to the root of the contract. This is a very, very important term of the contract and is also known as a condition. The other kind of term in a contract is a warranty. A warranty is a less significant term of the contract, and if there's a breach of a warranty, you're only entitled to damages. However, where there's a breach of a fundamental term, it amounts to a repudiatory breach of contract, and you're entitled to terminate the contract as well as claiming damages. There is also a third kind of term to make things more difficult, and that is called an intermediate term. Now, an intermediate term is kind of in the middle between a fundamental condition and a warranty. Now, if there is a breach of an intermediate term, then it will very much depend on the circumstances whether that entitles you to terminate the contract. If the circumstances of the breach are so serious, then it will entitle you to terminate the contract. But if, however, it is less significant, then you will not be entitled to terminate the contract and you're only entitled to damages. So I'm now going to discuss some examples of what fundamental terms are, specifically in the construction industry. So from the first bullet point, you will see that if a failure of an employer to give sufficient title to a contractor to enable them to carry out the work lawfully will amount to a repudiatory breach of contract, be a breach of a fundamental term, and entitle that party to terminate the contract if he so wishes. As you can see, however, it has to be a sufficiently severe breach. So for example, let's say the employer only has not given possession for 1 week after they should have done. That will not be sufficient to amount to a repudiatory breach of contract. You will not be able to terminate the contract. Now, as I'm sure some of you will be aware, in the JCT contract, it provides that you can have deferred possession. And it can provide up to 6 weeks that if you defer possession for up to 6 weeks, the employer, then the extension of time will be granted, and that's what will happen. But so given clearly here, if you can't terminate the contract if the contract clearly provides that you can defer possession up until 6 weeks. Therefore, what is clear is that after the 6 weeks, there will clearly be a sufficiently severe breach because you've still not given possession to the contractor, and therefore that will entitle the contractor to terminate the contract. Now, the clear theme that is running here, and you will see throughout today's seminar, is that you will be able to terminate the contract. You have a right to terminate the contract where the breach amounts to that party clearly evinces an intention to clearly not be bound by that contract. If they clearly are evincing an intention not to be bound by that contract because, for example, they're not giving, as in that first example, the contractor the ability to carry out those works, then you have a right to terminate the contract. And that is also clear from the third bullet point on the slide. Clear, unjustified order not to complete the works is a repudiation. That is because the contractor has a right under that contract to carry out the works. If the employer, for whatever reason, says, no, I don't want you to complete a certain section of the works, and instead I'm going to employ, that would amount to a repudiatory breach of contract. What I would state, however, is that in a contract, you sometimes have a right to omit works. Now, if you omit the works, that won't be a repudiatory breach because you're clearly complying with the contract. However, and this is where people sometimes the misconception lies, is that whilst you can omit the works, if you, however, contract the works to someone else, then that could amount to a repudiatory breach because you're giving the work to someone else when the contractor under the contract is entitled to carry out the works. As you can see from the next slide, another example which would amount to a repudiatory breach of contract, a breach of a fundamental term, entitling that person to terminate the contract, is where, for example, an employer engages additional contractors to execute the same works already contracted to another contractor. So let's look at an example. What sometimes happens, and I've actually seen this very recently, is that an employer will decide, the contractor, you know what, you're not carrying out the works to a sufficiently good progress. And what I'm actually going to do is I'm going to supplement the labor and bring in additional contractors to carry out those works that we've contracted you to do. Now, that would amount to a repudiatory breach of contract unless there is an express provision in the contract entitling the employer to terminate that, entitling the employer to supplement those works. If they don't have any such right and they decide to supplement the work, then that will be a repudiatory breach of contract because they shouldn't be doing that. The contractor is entitled to carry out the works and they should be exclusively given the chance to do that. But unfortunately, what some people do, the employers do, and this can cause a lot of trouble, is that what they'll seek to do is supplement the labor and then contracharge the contractor because they're not carrying out the works. Now, looking at an actual provision that was in a contract, the employer thought it meant that they could supplement the labor, but it could not. And it actually meant that the employer, when they tried to terminate the contract, actually wrongfully terminated the contract themselves, and that actually mounted a repudiatory breach. So the clause in question said, the employer is entitled to supplement the works if the contractor is not progressing with the works. Now, unfortunately for the employer, this was not a very well drafted clause because the question that arose is, well, what is progressing the works? Whilst the employer thought they're not carrying out the works to the level they're required, and that they would not carry out the works and complete by the completion date, they were actually progressing the works. They may have not been progressing the works very well. They may have been, yes, behind schedule, but they still were progressing their works. They were still coming in and doing some work. And in that situation, it meant that the employer was not entitled to supplement the works. Obviously, they interpret it as that they did have a right. And what that actually meant is that they committed a repudiatory breach. They committed a breach of a fundamental term. And it actually meant that the contractor terminated the contract and was entitled to damages. So I must say, and this is a running theme throughout today, you have to be very careful before you decide to terminate the contract, because it could actually amount to you committing a repudiatory breach because you've wrongfully terminated the contract. Another example, as you can see on the PowerPoint, is failure to pay. Now, often the clients who we are dealing with think that because an employer has failed to pay the contractor, that entitles the contractor a right to terminate the contract. And unfortunately, that is not always the case. As you can see from the PowerPoint, it very much depends on the circumstances of the case whether a contractor is entitled to terminate the contract. And the important consideration is, well, why is the employer electing to not pay the contractor? If the employer is saying, I'm not going to pay because I don't want to be bound by the contract anymore, then yes, that will clearly amount to a repudiatory breach of contract because they no longer want to be bound by the contract. If, however, they do not want to pay because they do not consider that all the works have been carried out or that there's defects, then you clearly will not be able as a contractor to terminate the contract. So it's clearly dependent on the circumstances of the case. But as you can see, a failure to pay is less likely to be a repudiation if it occurs towards the end of a contract, which makes sense. If they've already paid the employer a large sum of the contract and that towards the end they haven't certified one of the payment applications and haven't made the payment, that will less likely be a repudiation. So I would suggest that you are very careful in deciding to terminate the contract on the grounds of failure to pay. I would say that you do not do that unless there are a very clear example of the employer stating, I'm not paying because I do not want to be bound by this contract anymore. The final example on this slide, and the one I would say I see the most often as the cited ground for a repudiatory breach of contract, is where there's been an abandonment of the site by a contractor or removal of plant or site offices. Now, what I must state is that this will not in every situation amount to a fundamental breach, a breach of a fundamental term, entitling that party to terminate the contract. That is because you may actually have a right to abandon the contract. For example, if a party has not paid, as looking at the previous example we just discussed, there may be a contractual provision in the contract which entitles the contractor that because the employer has not paid, the contractor can suspend the works. So if you are lawfully entitled to abandon the site, that will not amount to a repudiatory breach. However, if you do not have any such right to do that, then abandoning the site will clearly amount to a fundamental breach. And I would say this is the clearest of all examples, because by abandoning the site, you have expressly stated, I am not going to carry out the contract. I'm not going to be bound by the contract, and this clearly amounts to a serious breach. Okay, so the next example I would say is another example that we all too often see, and unfortunately there is a misconception. A lot of parties seek to terminate the contract on the grounds that a contractor or a subcontractor has failed to proceed with the works with due diligence after having persisted on it after reasonable notice. So what happens is an employer will state, I'm going to serve a notice, it's a warning notice, saying you're not proceeding with due diligence, you're not carrying out the works diligently, and if you still fail to not carry out the works regularly and diligently, say within a certain reasonable period, say 2-3 weeks, I'm going to serve a second notice terminating the contract. Now, the difficulty here, and I would state, is one of the reasons why you shouldn't really rely on the failing to proceed with due diligence as a repudiatory breach and therefore seek to terminate the contract, is that it is very difficult to prove that the party is not proceeding with due diligence. It is very difficult to prove this. I would also say that it's even more difficult to do so at the beginning or reasonably towards the beginning of the contract. If you're at the beginning of the contract and the employer thinks, you know what, they're not carrying out the works with due diligence, the contractor will say, well, this is still a long period of time left before the completion date, and the works will be carried out on time. And it will be very difficult for the employer to prove otherwise. So what I would state is, if you are relying on a failing to proceed with due diligence as the reason why you want to terminate the contract, it is much more likely that you'll be successful in relying on it towards the end of the contract, because towards the end of the contract, it would be much more clear whether or not they're going to meet the completion date. But I would exercise caution in relying on this ground, because it can be very difficult to prove. The other thing I would state, and it's going to be clear on a later slide, is that you cannot really rely on the failing to proceed with due diligence if the contract provides for liquidated damages in the event of a delay. And the reason for this is that there will be an inconsistency. In one situation, you're saying, well, you're not proceeding with due diligence, I want to terminate the contract. And on the other side, well, you've already got a provision in the contract which provides that you're entitled to damages if they're not completing on time. So what I would state is, if there is a liquidated damages provision, then you're even less likely to be having a right to terminate the contract on the grounds of a contractor or subcontractor failing to proceed with due diligence. The final example, before we then talk about the second situation which arises where a party can have the right to terminate, is where there is an unjustified and continued failure to remedy defective work which requires removal or repair before further work should reasonably take place. So if you're an employer and you consider there to be defects in the works, and you require the contractor to carry out to remedy those defects, and there is a refusal to rectify those defects, and it means that because those defects have not been rectified, further work cannot be carried out, then this will amount to a breach of a fundamental term. Simply because there is defective work and a party is not rectifying it is not enough. It has to affect the further work that is going to be taking place, and you will need to provide evidence of that. Okay, so that was the first example. So the first example where you have a right to terminate is where there is a serious one-off breach, a breach of a fundamental term. As you can see, the second example where you would have a right to terminate is where there is a minor breach, not a serious breach, but it is a repetitive, protracted breach. It is a breach that the party is continuing to do, and because of that continuation, amounts to a repudiatory breach because it shows, as it says in the slide, it evinces a subjective intention not to be bound by the contract. And the best example I can give is simply where an employer has constantly notified the contractor of defects, whilst the defects, each defect being minor, but they are continuing and deliberately breaching the contract by not rectifying those defects. And given that continuation of significant amount of defects, it clearly shows that they're incapable of carrying out the contract. There's just so many defects, they're incapable of carrying out the contract, and it clearly shows a subjective intention not to be bound by the contract. So it's a breach of contract, but a minor breach. Clearly a defect has been taking place, and it's a continuous breach because there's more and more breaches and more defects, and they're not rectifying those defects. There's an inability to perform the contract properly. The third example is anticipatory breaches. This is the case where a party, for example, a subcontractor, actually informs the contractor, that he intends not to perform the contract as a whole or any part of it, either presently or in the future, or where he acts in such a way as to render his own future performance impossible. So the best example of this is, let's say, for example, a subcontractor enters into a binding contract with a contractor. They've agreed that certain works will be carried out by the subcontractor, and let's just say that the contract provides that the works are to be carried out in 5 weeks' time. Now, in those 5 weeks beforehand, let's say the subcontractor gets another tender and is successful and actually wants to carry out those works instead of the works it's contracted under. If the subcontractor then says, after the contract has been entered, you know what, I don't want to carry out those works, I've actually got a better offer somewhere else where I'm not going to carry out the contract, that would amount to an anticipatory breach, a fundamental breach, a repudiatory breach, and that would entitle the contractor to terminate the contract. And that is clear because the subcontractor has stated by his notice, by saying, you know what, I don't want to be bound by the contract anymore. I don't want to perform the contract. It doesn't matter that it was 5 weeks down the line. That does not matter. They have clearly evinced an intention not to be bound by the contract. It's an anticipated breach, and that will entitle the contractor in that example to terminate the contract. So what I've discussed so far is known as common law rights to terminate. In other words, it's rights to terminate that the courts have decided are certain situations in which entitles a party to terminate the contract. The courts have looked at cases and said, you know what, in that situation, that party has a right to terminate the contract. Now, in addition to common law rights, you can also have contractual rights to terminate. And what that means is that you can have certain provisions in the contract which provides that in certain situations you can terminate the contract, and that is all in accordance with and pursuant to the contract. And one of the examples, which is in this slide, is that you can actually have a contractual provision which provides a term which is actually not a fundamental term, which, as you'll remember from the beginning, is a term which goes to the root of the contract, and that will entitle the innocent party to terminate the contract. In other words, you can have a term which wouldn't have been a fundamental term, but is a fundamental term given the certain wording of the contract. And you can rely on that contractual provision to terminate the contract. Now, as you will see from the next slide, what parties try to do sometimes is use the words of the essence. They will say, time is of the essence, therefore, because of that, I'm making it a condition. It's a fundamental term that you complete on time. Because you're not, I'm entitled to terminate the contract. Or what they might say is, this is a condition, this is a fundamental term, this gives me a right to terminate the contract if this event happens. Now, unfortunately, it is not as simple as that. You have to look at the contract as a whole. You have to examine the whole contract to see that it is consistent with this intention. And this is something that I mentioned previously today. If you have a clause in a contract, a liquidated damages clause, which provides, for example, if there is delay, you're entitled to £3,000 for every week or part thereof that there is delay. Because the contract provides that you're entitled to liquidated damages, it is inconsistent with a condition in the contract which provides time is of the essence, because time isn't of the essence. You are entitled to liquidated damages if there is a delay. And because of that, there's an inconsistency. How are you going to be entitled to terminate the contract when you're claiming time is of the essence, when you're already entitled to claim liquidated damages? So you have to be careful if you are seeking to make amendments to a contract, because the whole contract has to be looked at a whole. The next slide says that where the parties insert express termination, that there is a situation where the parties insert express termination provisions for the benefit of a party in certain defined events. Now, as I'm sure most of you will be aware, you've obviously got the standard building contracts. You've got NEC, JCT. Now, the JCT and NEC contracts do provide for this. They have express termination provisions within the contract, and they state that in certain defined events, a party can terminate the contract. So this is in addition to the common law rights we've discussed. It's in addition to the common law right to terminate the contract when there has been a breach of a fundamental term. So by way of example, the JCT contract says that you can terminate the contract where a party is insolvent. So that is a defined event, and in that situation, you can terminate the contract. So the important thing to note is that you have the common law rights and you have the contractual termination rights. But the contractual termination rights are in addition to the common law rights. It is not the case that they replace them or anything like that. They are, as it says in this slide, addition to and not in substation of the common law rights. So that's something that's very important to know. You've got the common law rights and you've got to terminate, and then you've got the contractual rights to terminate. And what I will do at the end of today is explain what the differences are and in which situations it is better to rely on the contractual rights and in which situation it is right to rely on the common law rights, because there are advantages and disadvantages to both. So what we've just established so far today is that in order to terminate the contract, you have to have a right to terminate the contract. If you do not have a right to terminate the contract and you still attempt to terminate the contract, that will amount to a wrongful termination, and your termination will actually amount to a repudiatory breach entitling the other party to terminate the contract. And this is what always happens. I cannot stress enough, every single dispute we have on termination is exactly this. The employer, by way of example, will say, the contractor, you've done a serious breach, I'm terminating the contract. And the contractor will say, no, it wasn't a serious breach, and your termination was wrongful, and actually I'm terminating the contract because your attempt to terminate the contract was a repudiatory breach. And what you have here is a clear dispute where both parties are saying the other one has committed a repudiatory breach, and both are saying I've terminated the other party, that they've terminated the contract. And this is what often happens in adjudication. Both parties will be seeking a declaration from the adjudicator that the other party has committed a repudiatory breach and is entitled to damages. So let's say you have a right to terminate the contract. The question that arises next is, well, what can you do? And what is clear from the next slide is that you have two choices once you have a right to terminate the contract. So once there has been a breach of a fundamental term, you have two choices. You can either A, elect to accept the repudiatory breach and decide I'm going to terminate the contract, or instead you can decide to affirm the contract. And what that means is you treat the contract as continuing. So you decide to not terminate the contract. You decide I'm going to, you know what, I'm going to still carry on with the contract. I'm not going to terminate it. What I might do is still claim damages for the breach. So you have two choices, you have two different options to make, but you have to make one of the choices. What is clear though, however, is whatever choice you make, whether you decide to affirm the contract or terminate the contract, your choice has to be made clear. It has to be unequivocal, whether that's by actions or by correspondence. And that's something that I will look at in further detail in a moment. Now, as I mentioned, one of the options you can decide to do is to affirm the contract. In other words, you decide that I'm not going to terminate the contract and I'm actually going to treat the contract as continuing. Now, it is important to note that you can only affirm the contract. Firstly, you have to have knowledge of the breach. And secondly, you have to have your knowledge of the right between the two options. And this makes complete sense. You cannot affirm the contract unless you, first of all, are actually aware of the breach. And secondly, you're aware of your right to either affirm the contract or terminate it. So you can only affirm it once these two things are in place. Now, what I must state is that whichever option you decide to take, whether you decide to terminate the contract or affirm the contract, once that has been made, once you've elected to make your decision, you cannot go back on it. If you decide to terminate the contract is terminated. If you decide to affirm the contract, you cannot later down the line say, you know what, I'm actually going to rely on it, I'm going to terminate the contract. You cannot do that. If you do that, that will amount to a wrongful termination and a repudiatory breach. So once a choice has been made, you cannot go back on it. So for affirming the contract, it can be either express or implied. Now, it will be implied if, once you've had those two things, knowledge of breach and knowledge of your right to choose, you do some unequivocal act from which it may be inferred that you intend to go on with the contract. So if you do some sort of action which says, you know what, I want the contract to be carried out still, you order them, for example, to carry out further works, an order, for example, them to get more materials or something like that, then it may be implied from that conduct that you actually wish the contract to be carried out and you don't wish to exercise your right to terminate. But as I've said, that action will only be considered as an affirmation if that action is with knowledge of the breach and with knowledge of your right to choose. What must be stated, however, is that an affirmation of the contract, it will not be deemed to be an affirmation simply because the innocent party is requiring that party to continue the performance of the contract. That will not amount to an affirmation of a contract. Simply requiring them to carry out the works and say, please carry on, please perform, that will not amount to an affirmation. There needs to be something clearer. For example, requiring them to carry on ordering materials or something like that. It has to be a clearer action to amount to an affirmation. But as I've said already, whichever example you are deciding to take, whether terminating the contract or affirming the contract, has to be clear and unequivocal. And as this slide says, if you're deciding to terminate the contract, again, that has to be clear and unequivocal. But what I would say is that delaying in accepting the repudiation and terminating the contract will not be a bar. Simply because you've delayed and waited a little bit of time before deciding, you know what, I'm going to exercise my right to terminate, does not mean you lose that right. It will only lose that right if the delay is so significant that it actually amounts to you affirming the contract. So, as I've already stated earlier, what is often the case, and in fact happens most of the time, is both parties claim that the other party is in breach, both parties have committed a repudiatory breach, and both seek to state that the other party has terminated the contract. So the question that arises is, where both parties are in breach, what happens? And it is ultimately whoever's breaches first will entitle that party to terminate the contract. So what has to happen is regard must be had to the order in which the breach has occurred. So if whichever is the first breach, that is the important breach. It doesn't matter that one party is affirmed. Let's say that the second breach is let's say that there's two breaches. You've got the first breach and you've got the second breach. Let's say, dealing with the second breach, the party decides to affirm the contract and nothing has happened with the first breach. That doesn't matter. It doesn't matter which party acts first in response to it. It is all to do with the breach, which breach happens first. So by way of example, let's say a party has a right to terminate the contract and decides, I'm going to terminate the contract and abandon the works. That breach has happened first. The other party will say, there's actually been a breach, and the breach is you abandoning the works, and that's because you didn't have a right to terminate the contract. That is the second breach. The first breach is the contractors stating that the employer has breached the contract and is entitled to terminate the contract. And the second breach is the alleged breach of actually terminating the contract. Now, we had the order of the breaches, and then you have to look at, firstly, was the contractor entitled to terminate the contract? Was there a serious breach by the employer? If so, yes, and therefore they have a right to terminate the contract. If, however, the contractor did not have a right to terminate the contract, the employer did not do a repudiatory breach, the employer is then entitled to terminate the contract. So it all depends on the order of the breaches that occurred. So what we've discussed today is, first of all, the right to terminate, and when that right to terminate arises, you've got both the common law right and you've also got the contractual right. Now, the second thing that arises after this is, well, let's say you terminate the contract. What are the consequences of termination? Now, there are two consequences of termination. Number one, you're entitled to damages. And number two, it releases the innocent party from all further performance of their obligations. So this is important. Let's say an employer fails to pay and it does amount to a repudiatory breach of contract, and the contractor goes, I'm going to terminate the contract. What that means by releasing the innocent party from all further performance is that it releases the contractor from having to carry out any further works. The contractor has terminated the contract because of the employer's repudiatory breach, and by terminating the contract, it releases further performance of his obligations. He doesn't need to carry out any further work and doesn't need to remedy any of the defects. All of those provisions fall away. However, this is a very common misconception. It does not release the innocent party from rights acquired before the termination. Any right that you have acquired before the termination remains. So if you have a right to payment before the termination occurs, you are still entitled to that payment. Simply because the contract has been terminated does not mean that that right is removed. You still have that right. So as I've mentioned, the second consequence of termination is that you're entitled to damages. Now, the question I often get is, well, what damages are you entitled to? Now, the fundamental principle when it comes to damages is that the purposes of damages in this case is to put the innocent party in the position that it would have been had the contract not been terminated. So had the contract not been terminated, the innocent party would have been entitled, in this case of the contractor, to carry out the works and would have been entitled to any profit from carrying out those works. So the damages that the contractor will be entitled to for terminating the contract because the employer's repudiatory breach will be the damages, the loss of profit for the work that it couldn't carry out because the works were terminated, because the employment was terminated. And this is why it's often called loss of the contract, loss of the opportunity to carry out those last parts of the works. However, and this is a question I got on a recent seminar, is an employer said, let's say I've terminated the contract and I now want to employ another contractor to carry out those same works, caveated by the fact that it's going to have slightly additional more scope of works and the design is going to be slightly different. And the employer asked, because I've terminated that contract, that original contract with that original contractor, because the contractor has committed a repudiatory breach, am I entitled to damages to cover for those additional works that weren't under the original scope? And the answer is no, you're not entitled. All you're entitled to is to be put in the position you would have been had that original contractor not, had the termination not occurred and had the original contractor carried out those works. So it's only by reference to the original works that were contracted to. And that's something that's important to note. You would not be able to recover, for example, the 20,000 in relation to the variations or the change of design. You're only able to recover the work that was initially contracted to the original contractor. So as I've mentioned already, the rights that you've acquired before the termination remain. If you have a right to payment and that payment has materialized before the termination, that right remains. And indeed, the other right to remain are the provisions in the contract which provide that a party is entitled to refer a dispute to arbitration, adjudication, or litigation. Even though the contract has terminated, that party, whichever party, is entitled to still refer a dispute to arbitration, adjudication, or litigation. And this makes sense because every single day we're receiving disputes concerning termination of the contract where both parties are stating the other has terminated the contract. And they are relying on a contractual provision, specifically the right to refer the matter to adjudication. So what is key is that the provisions of arbitration and adjudication remain. You are entitled to refer your dispute concerning termination to the adjudication. The only situation where it won't arise is where you have an express term which provides otherwise. So in summary to the foregoing, what is clear is that you still can refer a dispute to adjudication or arbitration despite the contract terminating. And often what is the case is the actual dispute is concerning issues of termination, where both parties are stating the other has committed a repudiatory breach. And then it's up to the adjudicator to decide who's actually committed a repudiatory breach and who actually was entitled to terminate the contract. What I'm going to discuss now is actually looking at some provisions within standard forms of contracts. and briefly explain what those provisions mean. So what is often found, and this is in the JCT contract, is it says that notice of termination shall not be given unreasonably or vexatiously. Now, what the courts have found vexatiously to mean is to mean an ulterior motive to oppress, harass, or annoy. So if you elect to terminate the contract and the court decides, you know what, you terminating the contract was vexatiously, you had a motive. You really, the termination was because you simply wanted to annoy the other party. If that's the case, you are not entitled to terminate the contract. The termination will be seen as wrongful, and that will amount to a repudiatory breach. So the important thing to note from this slide is that if you are party to a JCT contract, you cannot terminate the contract unreasonably or vexatiously. If you do so, such termination will amount to a wrongful termination and will actually, in fact, amount to a repudiatory breach. The other often provision that we find in contracts is that it says, without prejudice to any other rights and remedies. And what this means is that in addition to, say, a certain clause which says you have an express right to terminate, you also have your common law rights. So this is something I was explaining earlier. Simply because you have a contractual right to terminate, for example, in the event of insolvency, this is without prejudice to any other common law rights that the party has. So the party also has a right to terminate the contract if there's been a fundamental breach. So what is clear is that, and I cannot stress this enough, you have both the common law right to terminate and the contractual right to terminate. What I'm now going to talk about is a little bit more detail about contractual rights to terminate. As I'm sure most of you, if not all, are aware, the JCT contract has certain provisions which provides that in certain events, you are entitled to terminate the contract. Now, what the contract will provide is that it often provides that you have to serve 2 notices before you can terminate the contract. The first notice being a warning notice, and then the second notice terminating the contract. And you can only serve that second notice if, after a reasonable notice from the first notice, the breach is still continuing. So you have the first notice saying there's a breach, and that if you do not deal with that breach, then I'm going to terminate the contract. And then if you still do not deal with that breach and the situation does not improve, then you can serve that second notice. Now, what I cannot stress enough, and you'd be surprised, but I see on a daily basis, is that when the party is seeking to rely on that contract and rely on those notices and rely on those provisions, they do not comply with the contract and they do not comply with the contractual requirements as to the timing and content of those notices. For example, the contract may state that the notice under clause 8.6, which is the event you're trying to rely upon, must be served by recorded delivery. And the amount of times I see that parties do not serve the notice by recorded delivery, you'd be surprised. I cannot stress enough that you must comply with the contract. Whatever the contract says, you do it. If you don't do it, then the other party will very quickly rely on that and say, you didn't have a right to terminate because you didn't comply with the contract. You didn't serve the notice by recorded delivery. The other thing that they don't comply with is that they don't terminate the contract in accordance with the provisions as to the timing of the notice. If the contract says that the second notice must be served 7 days after the first notice, that is the case. It can't be served 6 days or 5 days. So what I cannot stress enough is you must comply with the contract if you are relying on a contractual right to terminate. You must follow the provisions. If you do not, that will amount to a wrongful termination. Now, a question I get often asked is, let's say you rely on one of the JCT provisions and you serve the first notice. And the first notice says, there's been a breach by the contractor, you're failing to proceed with due diligence. I'm going to give you a reasonable period of time, say, I think under the contract it says two weeks, to remedy that, to basically improve the situation. The situation doesn't improve, and then you serve the notice 2 weeks after and terminate the contract. That is fine, provided you can show that the situation has not improved. However, what often happens, or what often the employer seeks to do, is actually rely on that first notice, but 6 months down the line, and say in 6 months, in 6 months ahead, say I rely on the first notice I served 6 months ago. You've still failed to carry out the works with reasonable due diligence. You cannot do that. You should serve a first notice again. You cannot rely on that first notice you served 6 months ago. What you should do is serve a first notice again, giving them a further reasonable period to try and deal with the breach, deal with the poor progress, and then seek to rely on it 2 weeks down the line. You should not rely on that first notice that was served 6 months ago. The final thing to note is actually to the content of the notices. What I recommend you do whenever you are seeking to issue a notice, whether that be a first notice or second notice, is to repeat what is in the contract, to state the clause number you are referring to, and to state exactly what the wording of the provision is, so that you are clearly stating to the other party which clause you're relying on, which clause you are stating you are electing your right to terminate under. Now, as I'm sure you will be aware, there are more than one express provision in a contract giving a right to termination. There may be 4, 5, 6 different situations under the contract which might provide a right to termination. And it may be the case that there are more than one situation that is currently happening which you seek to rely upon. And that's no problem at all. So what you would put in the notice of terminate, the first notice or second notice, is you would say, I am seeking to rely on clauses 8.6, which provides as follows, and clause 8.7, which provides as follows, and please accept this as a first notice. And then state that if you fail to remedy the situation within 2 weeks, as per clause I will then be terminating the contract. So what you do is then you're saying the alternative situation, and that's often how we phrase any notices on behalf of our client. We will say in the first instance, we're seeking to rely on this, and further in the alternative, we're seeking to rely on this. What we actually do is a belt and braces approach, and will also state in the notice of termination any common law rights to terminate. So we will say we're relying on this clause and this clause, but further in the alternative, we're relying on the common law rights to terminate, which, as you remember at the beginning, for example, we're saying there's been a breach of a fundamental term entitling it to a repudiatory, entitling that party to terminate a contract because it's a repudiatory breach. And that's in addition to the contractual rights. So the final thing to state before I conclude and explain about which right you should elect to exercise, both being a contractual right and a common law right, is this slide, which says that if a party refuses to perform a contract, giving a wrong or inadequate reason or no reason at all, he may yet justify his refusal if there were at time facts in existence which would have provided a good reason if he did not know of them at the time of the refusal. Now, this is very important, and it's best expressed by an example. Let's say a contractor believes he has a right to terminate the contract and does so. Now, unfortunately, the contractor was wrong, and the reason they are relying upon is not actually, for example, a fundamental breach. And actually, they shouldn't really have terminated the contract. However, let's say later down the line, they find out that at the time they terminated the contract, there was some other reason which would actually entitle them to terminate the contract. They can rely on that reason. It did not matter that at the time of the termination, they did not rely upon it. It does not matter that at the time of the termination, they did not know of that reason. So this is important. If, for example, at the time of termination, you say you didn't proceed with due diligence, I'm going to terminate the contract, but actually that was a poor reason. If another reason later down the line comes to your attention, which was occurring at the case of that termination, for example, a breach of a fundamental term, such as something in the contract that you were expressly provided not to do, then you can rely on that reason. That will not be a wrongful termination simply because you did not cite that reason. So, as I mentioned throughout today, you have two different rights to terminate. You've got the common law right to terminate, which the courts have imposed, for example, a breach of a fundamental term. And in addition to that, you've got the contractual rights to terminate, the specific clauses in the contract that you seek to rely upon. Now, the question that I often get is, well, which one do I rely upon? Do I rely on the common law or do I rely on the contractual right? Because it's often the case that both exist at the time. You could rely on both. Now, there are both advantages and disadvantages to both. The advantage to relying on the contractual right to terminate is that there is, for example, in the JCT contract, a certain provision which provides what happens when there is a termination. There is a clause in the contract which provides what happens after the termination has occurred, relying upon that termination clause in the contract. So, for example, the contract may state that if you terminate the contract under clause 8 point whatever of the contract, then the consequences of termination are as follows. And it may state that any issues as to the final account are dealt with after practical completion. So the main advantage of relying on the contract is that it provides certainty. You know exactly what happens after the termination. It's all in the contract. You have to rely upon it, but it's very clear what happens afterwards. There's a lot of certainty. And this is the issue with a common law right, is that there is less certainty as to what happens afterwards. However, the advantage of the common law right to terminate is that it is immediate. As I've said already, with a contractual right, you often have to serve 2 notices, and you often have to wait a certain period of time after the first notice before you can serve the notice of termination. With common law rights, you don't have to wait. As I've already mentioned, if you have a serious one-off breach, if that breach is so serious, you can terminate the contract straight away. And in certain situations, either the employer or contractor might want to terminate the contract immediately. So that is the main advantage of relying on a common law right to terminate, is because you can terminate the contract quickly. The issue, however, is that there is a lack of certainty, and I would also say that there's a bit more danger that perhaps the breach you are seeking to rely upon is not actually a repudiatory breach entitling that party to terminate the contract. So the final thing I would note is that, and I hope that you've got this from today, is that you have to exercise a lot of caution before you decide to terminate the contract. The reason being is that if you decide to terminate the contract and the termination is wrongful, you yourselves have committed a repudiatory breach. The other thing is even if you did have a right to terminate, if you don't follow the contractual provisions and don't follow the timing and content of the notices, then you could still also have committed a repudiatory breach. So you have to be very careful before doing anything. So if you have any questions in relation to this, ever want to run through anything before deciding to terminate the contract, please do not hesitate to contact me, because the very significant issue is that if you terminate it wrongfully, then not only are you not entitled to claim damages, but the other party can then claim damages against you, and you could therefore have a significant claim against you. So if anyone has any questions, then I will be happy to take them.
Okay, thank you for that, Brandon. We've we have had one which came in fairly early into the conversation from someone, sorry, who said they have a hotel refurb project that has been in suspension due to COVID. The project has never actually made it to site, but as you'd imagine, a hell of a lot of work has gone into getting the contract in place. It has now been finally decided to voluntarily terminate the contract by both parties. The contracting in question is a JCT without quantities. So the question is inaction in this now agreed termination? Do you need to term it either force majeure or a frustrated event, or is that necessary as it's a voluntary termination?
I would say that's not necessary, because I think there's an agreement in place between both parties. And because there's a voluntary termination, both parties have clearly agreed it, so there won't be any contention. You can obviously state in that agreement that the reason we are terminating is for these grounds, on the grounds of force majeure because of COVID, but it doesn't really matter about stating the exact reason. But there is often now certain bespoke amendments to contracts which actually provides for what happens when there is COVID. So when there is COVID, and for example, and I say it's less relevant now, it was more relevant when we had the lockdowns earlier, but there were certain provisions in the contract which said what would happen when there was a lockdown. And that's something that we also do, is that we draft bespoke amendments to standard form of contracts, which deals with situations of COVID.
Brilliant. Okay, that seems to cover the questions for today. So thank you very much. As everyone can see up there on the screen are the next upcoming seminars. We're back with Mohammed Hack tomorrow at 6 p.m. for the latest in his adjudication matters, which is all about enforcing and challenging a decision. And then next week, we have conflict avoidance in practice on the Tuesday, the last one in that series with RICS, project security and guarantees, and programming and time with NEC and JCT. If you'd like places on any of these, please email me seminars@fletcherday.co.uk. Thank you to Brandon for this morning's presentation. And as Brandon says, it's brandon.silver@fletcherday.co.uk if you have any direct or specific questions you'd like to talk to him about. Other than that, I wish everyone a great Wednesday. Brandon, we'll see you soon. And take care, everyone. Thank you very much.